have a little. All right, we'll call to order the October 19th, 2022 Cottonwood Heights Planning Commission meeting. Welcome those in attendance, and doesn't look like anyone. Oh, we have one participant on.
Where is that coming from?
I'm not sure. Hold on. Not sure. Preview.
No. That's
Okay, try now.
that
Okay.
was good.
Oh,
I thought it's playing. Somewhere
I know where it is.
playing.
But there we go. We got it. You're good to go.
Okay. Okay, great. Thanks. Technical difficulties.
Yep.
Welcome those in attendance. We have one person on Zoom, it looks like, joining us. We may have Commissioner Ebler join us on Zoom. The rest of us are here in person tonight. Does anyone have any ex parte communications or conflict of interest to disclose? Seeing none, we'll move on to general public comment. Is there anyone here from the public that is here to give general public comment on an item that is not on the agenda tonight? Seeing none in person, is there anyone on Zoom? There's Commissioner Epler. All right, we do have a hand raised on Zoom.
Yes. I am Dan McDonald. I am legal counsel for Vamsi Yaganti and his spouse, who are the neighbors to the applicant, and filed a written objection as well
Dan.
as appeared at the last meeting.
So, sorry, Dan, we'll just, we'll hold your comment till we get to that agenda item, which is next.
Oh, I apologize. I thought you'd moved on. I'm so sorry.
No problem. So I'm seeing no public comment, so we'll go ahead and close the general public comment time, and we'll move on to our business items, which is project CUP 22011, a public hearing and possible action on a request by Catherine Pasker on behalf of Robert Brine for a wall height extension to construct an 8-foot wall along the northwest property line at 7275 South Calidora Cove. This is the second time we're hearing this business item, and we discussed this in the working session earlier, and so staff does not have any additional information to provide at this time, so we'll skip the staff presentation on this item and move to general public comment on this project. And we can now move on to Dan, who is here for public comment on this item.
Yes, thank you. May I speak for just a moment?
Yes.
Thank you. I believe my
Can we
law
start the
partner.
timer?
Go ahead.
Yeah,
Dan.
okay. I believe my law partner Kyle Fielding spoke on this on October 5th and set forth our position. Real quickly, if there's any questions, I'm happy to answer those in regard to our position, but we do believe this is technically a building structure. However, even if it's considered only a fence, it does not meet the rigorous, clear and convincing evidence standards under the law, which is the most rigorous standard right below beyond a reasonable doubt in criminal cases. The applicant doesn't meet that high burden. There's no unique or special circumstances of a natural, material, or adverse nature that are minimized or eliminated by granting a conditional use permit. Really, the only justification is privacy, but this is a self-imposed, self-inflicted hardship that the applicant is facing. And this is not the most reasonable solution. Putting the dogs closer to my client's house is not the most reasonable solution. It's the backyard. And further, we'd just like you to consider the fact that this applicant violated the law, was cited criminally because it's a misdemeanor to build a fence without a building permit and without a conditional use permit. And this fence was built after it was represented that they were withdrawing the prior conditional use application. So there's no equitable or mitigating circumstances whatsoever that would justify granting this conditional use permit. My clients would like to see it torn down. It was built in violation of the law, and you should uphold the rule of law. That's all we have to say, unless you have questions.
Does anyone have questions for Dan? All right, thank you, Dan. Is there anyone else here for public comment on this item? No, since you're representing the applicant, you can go ahead and approach now if you want to. Go ahead. Yeah. The mic on.
There we go. A green light turned on. So let me start again. So my name's Jim Wright, and I'm an attorney with Parr, Brown, Gee, and Lovelace. And my colleague Catherine Pasker previously represented Rob and Ashley Byrne, and she just recently moved on to join Salt Lake City. And so I'm transitioning here now as representing Mr. Byrne and Ms. Byrne on behalf of Parr Brown here. So maybe if I can, before I address just a couple of things that Mr. McDonald raised here, I just want to just focus the attention of the commission on the issue that's at hand here. You know, the issue at hand is not whether or not this wall should be torn down or not torn down. We are talking about is, and hopefully you've had a chance to review the materials that we submitted. There was a depiction here of this wall in green. Perhaps you recognize this this depiction here. And there's a very small portion of this wall that exceeds the allowed by right height of 6 feet. Okay, and so the only thing we are considering here tonight is not whether this wall can stay or not stay. It's whether Mr. Byrne has to, you know, carve off a little piece of this wall here represented by this blue triangle so that the wall height does not exceed 6 feet. And I mean, I say wall, but I'm saying, I mean, it's the same. The word you use in your ordinance is fence. And I don't think, you know, I know staff has looked at this, and I think that, you know, there's really not a reasonable argument that we've heard that this is not anything other than a fence as defined in your code. You know, it's clearly a barrier of any material or combination of materials erected to enclose, screen, or separate areas. That's in the Cottonwood Heights ordinance there, 79, 76, 50 E subpart 1. And so now the next thing I just want to just briefly focus on, because I don't need to rehash, you know, everything that's already been said here, but, you know, Mr. McDonald raised the question of legal standard. And so the question of legal standard is clearly set forth in Utah state law. It's in state statute, and it's found in 10-9A-507 conditional uses. And in that statute, 2A says, subpart 1 says, a land use authority shall approve a conditional use if reasonable conditions are proposed or can be imposed to mitigate the reasonably anticipated detrimental effects of the proposed use in accordance with applicable standards. And so, you know, I don't want to get too much into the city's ordinance here. I think that, you know, staff has already indicated that, you know, they believe we've met even the city's code. I need to go on the record here as saying we believe that the ordinance is in conflict with this law. And so in case there's appeal, I just want to make sure I'm on the record as saying that. Again, there's a transition between attorneys here, so I don't know if she fully got that out in the record and vetted, but you know, the city code can't change what the state law says the standard is. There is no clear and convincing evidence standard. That's not the standard for conditional uses. It's set forth here, as I just mentioned to you. And so, you know, maybe I can just briefly then say, we haven't heard of any detrimental effects that have come into place with respect to this little strip of fence that exceeds the 6 feet. You know, I'm not aware of any on the record. You know, if there is, it'd be great to hear just so we could address it. But there has to be a detrimental effect shown that then can't be mitigated by a reasonable condition. Okay, the only condition we're aware of is a building permit needs to be you know, applied for an inspection, right? That makes sense. You know, as the fence gets higher, there's a safety concern. You know, in case it were to fail, the higher it gets, the more of a safety risk there is. That's a reasonable condition to impose. You go in there, you have the building inspector come and make sure that it was constructed in accordance with standards and that it's safe. Okay, no dispute here. But that's the only detrimental effect that's been set forth on the record. You know, people not liking it is not a detrimental effect. And we have to again remember that this fence can stay there up to 6 feet. And so, you know, for the conditional use permit, which is that small little piece, you know, we have seen no detrimental effect on the record other than potentially safety that's been addressed by a condition. And therefore we would submit that based on Utah law, this has to be approved. If we're talking about the rule of law and upholding legal standards. And if I might just very briefly, you know, since this was brought up by Mr. McDonald, there was an honest misunderstanding by Mr. Byrne when this fence was initially constructed in terms of why he retracted his conditional use permit at the time. Again, I understand that the city is going to have a different position about what happened, and we don't need to decide who's right or wrong. I just wanted the commission to know that there was an honest misunderstanding on his part. And so this is the attempt to go through the correct process to make sure that everything is complied with and that we have received the appropriate approval under the appropriate standard that applies in the law. And so we very much appreciate your consideration here. You know already that this is not just a general privacy concern, you know, in terms of if, you know, again, as I mentioned, we don't believe that the standard in the code necessarily applies. We think that the state law trumps that. But even if we assume that it did apply, we think he has shown by clear evidence. And you know, there's a real need here for this slightly higher area fence here because of the real safety concerns for his family. As you know, there have been multiple incidents where there's been direct harm to his family, rocks thrown through a window, you know, stalker, he has a protective order. I mean, there's some real issues here that we don't believe were in place. And the 10 out of 10 other times the city of Cottonwood Heights has approved a conditional use for a wall above 6 feet. So I'd be happy to answer questions and to, you know, address anything that the commission or you know, any city staff has for us.
Does anyone have any questions for the applicant? Does Commissioner Ebler have any questions for the applicant online?
I could.
Let's make it interesting.
Yeah, give me a second. So I read over the public comment and whatnot that you submitted, and I'm still having a hard time rationalizing, you know, some of the issues. The precedent I don't think has any bearing. Every conditional use has to be considered in a bubble and whatever else. So like whatever other planning boards have done, I don't think has any bearing on this case. So we're bound by the law in terms of making the determinations based on section 19.84 of our code, and then specifically 19.84.080 in the determination. And there's 16 criteria that have to be satisfied to provide for the conditional use. And there are certain criteria within the determination of that subsection that I struggle with, just because the neighbor raised questions that seem to not comport with that determination. So I'm struggling with that piece of it. I mean, I can point a couple things out to you.
That might be helpful. I'm not quite sure how to respond. I don't have anything specific.
Okay, so there's 16 criteria. A lot of them I think are fine, but there's a couple in particular. Paragraph 2 says that such use will not, under the circumstance of the particular case, be detrimental to the health, safety, comfort, order, or general welfare of persons residing or working in the vicinity.
So I guess with that one, maybe is it okay if we address that one, or do you want to get them all out on the table first before I respond?
Yeah, I'll just go to another big one. The appropriate buffering will be provided to protect adjacent land uses from light, noise, and visual impacts. I mean, there's other ones about it being harmonious to neighboring uses, and the nuisances which would not be in harmony with neighboring uses would be abated by conditions imposed, et cetera, et cetera. I mean, like I said, I mean, there's 16 conditions. I think a lot of them aren't necessarily applicable, but I think these in particular probably are. I didn't give a lot of weight to the attorneys of the neighbors' opinion about the structure and whatever else. But they brought up other things in terms of nuisance and noise and whatever else that I think are applicable in terms of I'm having a hard time harmonizing their objections with the determinations.
So, maybe Rob, why don't you just let me look for that? All right. Yeah, no, it's, yeah. So maybe, Commissioner, would you like me to address the ones you raised there?
Sure.
And first of all, I appreciate the, setting that forth. And again, just want to say, I think that, just again, so I'm on the record, sorry, this is just in case you have to appeal this. I don't think that those standards are lawful based under the Utah statute that I previously referenced, but that aside, let me address them. And so in terms of, the health, safety and welfare, I guess I'm not sure what detrimental effect has been pointed out by the presence of the small strip of wall that's over 8 feet. I'm struggling to see what sort of health effect or safety effect that's going to have on anyone or anyone's welfare.
So you said it runs contrary to what, 109A 507?
Yep. Mhm.
Okay.
Like I said, we don't have to decide that here. I'm just saying,
Sure.
I'm just putting it on the record for in case we have to appeal this. That's all.
No, understood. And obviously, like, I'm just ensuring that, like, that it's not arbitrary and capricious, and we're following the letter of the law, and there's 16 determinations that have to be considered. And that determination should be made under those 16 criteria.
So let's go ahead and again, addressing them. I guess I'm not aware of any, detrimental effect that's been put on the record of a health, safety, or welfare, effect of this small piece of wall that exceeds a 6 foot height. I'm not. If there's anything specific we can respond to on that, I'm happy to address it, but I just don't see how there's any health effect, how there's any safety effect.
I mean, so in the application, it was specifically called out that in terms of like it would be, for the dogs or whatever else, correct?
And again, I apologize if I'm not quite as familiar. I think that the real reason, it is a fence. The dogs do run through there. The dogs are not, and Rob, you can correct me if I'm wrong, but the dogs do not stay there. Those dogs are not fenced in there. This isn't the place to keep dogs. Is that correct? Yeah, it's really, it's dogs.
We need you to have, we can only take the comments that are going into the microphone, so
I can't hear it.
yeah, go ahead. Sorry, I mispronounced your name earlier.
Robert Byrne, that's okay. It's funny that this all has been misconstrued as far as the dog run being the primary reason that I, built that fence. The primary reason I built this fence is security, and that is the only reason, really. I mean, privacy is great, and you gave conditional fence to people for that, 10 out of 10 or 16 out of 16, whatever it was last year. Okay, and everybody has pretty much avoided the idea that I have a person who is a psychopath, who used to be a friend of mine. He recently put a bomb under a person's car and blew it up and tried to kill him. He has also been in my backyard. He has threatened my family, my life, my wife's life, my children. He threw a rock through our window and almost killed my son. It landed right next to him on the bed. My kids can't even sleep anymore without crawling in bed with us because they're afraid he's going to come and kill them. He filled my hot tub with flowers, filled it with flowers just for the heck of it. He threw a huge vat of transmission fluid into my pool. He went to jail. It was the best 5 months of my life, but during that 5 months, I built a fence around the back of my yard. I put in new security. I put this plan out for this garage and for the wall. And the reason I have an 8-foot wall in the back is because he's 6'2". And he's gonna come over a wall and 6'2" in the back because it's not that he gets in the back. I have cameras everywhere. So there'll be notifications when he gets over the front of the wall that's 6 feet. But I have notifications that come to me right away. Then if he tries to get in my backyard and do something stupid, well, he's gonna have to get out of there before I call the cops and so forth. And I have cameras all there as well. I spent over $500,000 in security. And that includes the gym and the fence. So this isn't about privacy. It is about my kids getting killed, okay? Because he has threatened that. And you, as Cottonwood Heights, I live in Cottonwood Heights. To me, this group is supposed to help me. We pay $250,000 in tax for the state. That's not IRS. I pay for people's, I pay for your paycheck, some of it, potentially. And this is the way that we're treated. I mean, anyhow, I'm losing it right now. So anyways, it's more than this, okay? It's more than that 6 inches or a foot in the back of that wall. This is about my family and me protecting them.
Yeah. Thank you. So yeah, I appreciate Rob's, his statement there. And again, I think that, I can go back to, I guess, addressing these other issues raised by you, Commissioner. But again, just remembering that it's not a question that this wall was built to hold dogs, because we're only talking about, clearly that's not the case based on Mr. Burns' testimony there, but we're only talking about that small blue portion in the depiction. Okay, so let's just say that for whatever reason, the conditional use permit is not allowed, we lose on appeal, etc. The wall is going to stay there. It's just going to have a little bit of a, and I'm not saying that as like a threat, I'm just saying under your own ordinances, right? I mean,
Sure.
the wall is allowed up to 6 feet.
Sure.
And so, we're really only talking about that little triangle that gets shaved off. And so I guess that's going to make no difference on whether dogs are there or not. It's going to make no difference on really anything other than the well-being of Mr. Byrne and his family. And so
Well, yeah, but I mean, but
it's
the
hard to say
reality
what the
is that we,
detrimental effect is. And I just haven't heard it.
yeah, but I mean, but the thing is we're not just talking about, yes, a conditional use is on the wall, but it also got gated in, correct? There's a gate by the stairs.
Maybe, but again, all we're talking about here is that little blue piece. It's only the portion of the wall that exceeds 6 feet. That's the only thing before this commission.
Yeah, but 100% true. But like you also presented a whole bunch of arguments to us about it being about the dogs and about about privacy and about this or that. And it's like, so these are all things before us that are on the record.
Yeah, and
Mr. Chair, can I step in and suggest that we have all the facts of this case and should probably move forward to deliberation now?
All right. Commissioner Ebler, do you have any final questions for the applicant?
I think Mr. Johnson's comments were very apropos.
Okay.
I thank you, Commissioner, and the whole commission. So thank you.
Sorry for monopolizing the conversation. We're a deliberative body. I get 1 vote.
Thank you. All right.
Anything further from me the commission would like, or
Anyone else? Okay, no, we're good.
thank you.
Thank
Appreciate
you.
it. Thank you.
All right, is there any discussion amongst the commission?
Quick bit of discussion, and I just want to make sure, and this could be a question for Mr. Johnson and the Seal Horse as well, but we don't have any jurisdiction of what the applicant does inside of this space, as long as it's not building a structure. We don't have any jurisdiction in if he's building a fence or a gate inside of this. Is that correct?
Well, you're talking use of the land. No, if it's used for residential purposes and anything pertinent to its residential use, that's allowed. It's a single family residential zone. Things like steps and railings and things like that have building code components, but they're allowed. And whether the fence is 6 feet or 8 feet doesn't change how the building code or city ordinances apply to those things.
Thank you.
Any other questions? I would then entertain a motion. Anyone would like to make one?
Before we do, I would just like to put on the record, in case, as the applicant's attorney indicated, if it does go to appeal, I do not feel that 19.84.080 on the determination has been met for conditions 2 and 11.
Thank you, Commissioner Ebler.
We don't have model motions pulled up, but I will just remind the commission of the file number for this project for anyone who would like to make a motion. This is project CUP 22011. And Mike may have something to pull up. here to provide the motion.
Really quick before we do jump into that. I want to better understand Commissioner Ebler's reason behind those two not being met. I just want to better understand your reasoning for that.
Sure. So, you know, this case is, I think, a little hard because, like, on one hand, we decide things in a bubble and we're deciding offense and whether or not it complies or comports or whatnot. But on the other hand, we do have a neighbor's complaints that there are noise issues. There are issues. And you know, and then this isn't an issue about utility screening and whatnot, because the conditional use is on the sloping of the land, which is not where the, you know, utilities are or whatnot. But the, you know, there was a, you know, from one of the views and one of the land plats, I'm fairly certain that there's a gate that basically boxes in this area. And so it's not just that, it's a fence and whatever else, like a normal fence that a lot of people have. This is a very, very specific area that is boxed in for a very specific purpose. And certainly the planning commission could opt to propose a condition to remove any fencing on the interior of that, so that it's just, you know.
Would that be in our jurisdiction?
I don't know.
That would be something that would be within the 6-foot fence area.
Yeah,
and I just want to see kind of your point that you brought up.
But the thing is I this is a part I'm like concerned with and also curious about, because city staff has said, you know, there's no structure, there's no like roofing elements and whatever else, and that's in their purview. But like certainly like what happens also in terms of boxing it in seems that it should be in the purview also, right? Or no?
The staff's perspective would be like this. I can build a driveway on a property and I can park a car on it and I can walk on it and I can play basketball on it and I can have my dogs walk on it. It's allowed to be there. It's something that's allowed by city code, and the use of it is tied to the use of the property as single family residential. And whether I have a no fence or a 6-foot fence or an 8-foot fence, I'm still allowed to use that portion of the property for a residential purpose as I see fit.
And I want to better understand your perspective on that, Commissioner Ebler, out of all respect, just from making, you know, the decision to vote for against this, just because what is inside of that 6-foot section of the fence is not in our purview, truly. Whether it is a gated off garden or a place that a dog runs or a place that the kids play, that is not in the purview of the planning commission and from a deciding factor for this, just from my perspective. So I want to better understand yours so that we can vote appropriately on this.
No, I 100% agree. But like, if that were true, this wouldn't even come before us. And you know, if they took a concrete saw to it and sawed it off to 6 feet, it wouldn't come before us, whether or not it was gated or not. But that's not the case. And it is over 8 foot and it is before us. And so, you know, we can either vote it down, we can put conditions on, or we can just say it's fine. I'm just having a really hard time making the logical determination when you have a neighbor who's retained legal counsel saying there are noise issues, there are nuisances, it impacts my general, you know, health, safety, and welfare, which is one of the criteria of the determination. And even though it doesn't need neighbor consent because it's not over the 8 foot, it seems to me to violate the subsection of the determination. So like, I understand that like 10 out of 10 have been approved, but maybe those were just like back fences and whatever else, and it just wasn't an issue.
So I think in that regards, I mean, the spot that and that's why in our working session, I asked Mr. Johnson to pull up the Google Maps on this to see where that kind of gate close off is. That is, from what my understanding is within that 6 foot section. So that would be just built by right. So the 8 foot section, as the applicant's counsel had mentioned, is really that tapered section of triangle that we'd be focusing on. So the counter argument to this of the neighbor would be to basically chop that triangular section of the western part of this fence to meet code, not to completely tear it down, because that's what the applicant or the counter argument is to completely tear this down, not to bring it to code. So I think that that's, from a planning commission perspective, what we need to be looking at is to bring this to code, not to completely tear it down as what the counter argument is to this.
No, I agree. And like the thing is like the houses are really close together, and does a fence or wall make sense there? Sure, absolutely. The fact that it's being, I think I heard you say, Commissioner Steinman, that the gate was within the 6 foot section.
From Google Maps perspective, I believe it is, and we can have.
I thought it was at the back end of the stairs, which was at the 8 foot section.
You want to pull that up?
Well, I don't have a photo of the new gate. I think you could put a gate anywhere inside that fence.
Yeah, it's
I don't know how that is applicable here, whether the fence was 6 or 8 feet or existed or not. You could put a gate on that side yard anywhere.
I come back to the simple discussion, was the initial fence legal or illegal? And the only section that would have quote unquote been illegal or require special remedy, the only and we've seen some off-base discussions on both sides in terms of what the rationale is in my view, but the simple discussion about privacy is what the city has previously made decisions based on, and 10 out of 10 decisions based on quote unquote privacy and the interpretation of privacy. Based on the fact that we've made those determinations previously, simply based on privacy, if we wipe away all the other arguments, however, vague and obscure, I think we're left with a very simple decision about whether or not this is reasonable to ask for to increase privacy. And because it's a slope, we've talked about this before. There are slopes all over Cottonwood Heights, and we've allowed this as a mitigation to mitigate slopes in Cottonwood Heights for quote unquote privacy in the general sense. And privacy, period, end of discussion. No interpretation of what privacy is, but we're 10 out of 10. So I think, to me, that sets a pretty, consistent standard for us.
And I would agree, but I also want to bring up that I don't see the detrimental effect of this additional piece on the 6 foot piece. I mean, what the detrimental effect of that, I am not saying is that is one of the criteria for evaluating whether it should be approved or not, and is that this would be detrimental. And I do not see that noise and that kind of thing is not relevant here. That's handled by code enforcement and not by the planning commission.
No, I would concede that point if this wasn't built and there wasn't a gate at the other end, which basically, like if you let dogs out into a small area, the noise is where the noise is. But the applicant made the argument about the dogs, in the yard and whatever else, and it's like, but it's a big yard, and you're basically hyper focusing dogs into a small area. you know, certainly there could be, you know, conditions of like, sure, there, you don't enclose that because it's so narrow and it's so close to the other house. I think it's, I don't think it's arbitrary and capricious standard to assume that, like, you know, a wall should exist. I don't necessarily have an issue with that. I think what I have an issue with is like a wall exists, but you're also creating a rectangle that exists for a very, very specific reason. When you have a fairly large yard, and if like you just give the dogs the run of the yard, they're not going to stay in that box. If you stay in that box, they're gonna pose, you know, noise and welfare situations to the neighbor. If they're not boxed in there, that doesn't exist.
So to your point in that regards, our focus as the planning commission in this, from my understanding, is really the only section of 8 foot. If it was 6 foot all the way down and it was still identified as that's where he puts his dogs, we don't have any jurisdiction over where he puts his dogs in his private property. And if his dogs do make noise, then the noise ordinance is going to then come into effect on that. But
Sure.
if he decides to put his dogs in a 5x5 section on the, you know, whatever angle, we have zero jurisdiction over that. All that we're looking at on this is the 8 foot height, not even the 6 foot height, truly.
Yeah, I 100% agree with you. And it's like, it's one of these weird things of like, on one hand, everything you said is 100% accurate, but on the other hand, it's like we have the reality of it's built, and we can also look at the situation of, okay, there are impacts. Some of those impacts do potentially violate some of the determinations. And so can we put conditions on those impacts that mitigate those impacts, which is what we're supposed to do? Because like we can approve the conditional use if we can mitigate the impacts.
I move that we call a question, which requires a second and a vote.
I second.
No, the move is to call the question, which means that we vote on whether to end debate. And if there's enough votes, then we call the question.
Do we,
Or
do we
am I
vote?
misunderstanding Robert's rules?
That's
That's
correct.
fine. I think we can,
It's correct.
All right, Commissioner Shelton,
yes.
Commissioner Mills,
Yes.
Yes,
Commissioner Steinman,
Yes.
Commissioner Ebler.
Yes.
All right, and Commissioner Allen, yes. So then we will entertain a motion.
I move that we approve project CUP -22-011 based on the recommended conditions and findings in the staff report dated October 5, 2022.
Second,
All right, we have a motion and a second. Is there any discussion?
Yes.
Go ahead, Commissioner Ebler.
Again, I want to put on the record that I feel that because it exists, because the neighbor has objected about noise and welfare, that we can't make the determinations under 19.84.080 under paragraphs 2, that such use will not, under the circumstance of the particular case, be detrimental to the health, safety, comfort, order, or general welfare of the persons residing and working in the vicinity. And 11, that the appropriate buffering will be provided to protect adjacent land uses from light, noise, and visual impacts. That we cannot support the application without additional considerations like the removal of the gate that creates the box. It's just a comment, and I'm just putting it on the record.
All right, thank you. So no addition, is there any other discussion or conditions that anyone would like to add?
No.
Hearing none, we'll call to vote. Commissioner Shelton,
yes.
Commissioner Mills,
Yes.
Commissioner Anderson,
yes,
Commissioner Steinman,
Yes.
Commissioner Ebler,
No.
Commissioner Allen, yes. All right, then that closes project CUP 22-00011. And we don't have any minutes or anything else on the agenda. So do I have a motion?
Move to adjourn.
No, we'll have 2 minutes on our next one because of the double meeting in October. We weren't able to, that was my bad to not get them to you earlier. So we'll just do 2 meetings worth in November.
Thank you.
Move to adjourn.
Second.
All right, and all in favor?
Aye.
Aye.
Anyone